going to go through the list of those who are on the phone again, and if I can find that. So just going to the phone right now. Is Mr. Bannock on the phone? Mr. Furlong? We got the, is the phone on? Mr. Lerner?
The conference is no longer in lecture mode.
Sorry, Mr. Treasurer.
Mr. Bannock, how's the rocket ship going? Mr. Bannock, are you on the line? Mr. Furlong?
I am here, thank you.
Mr. Lerner?
Present.
Ms. Richardson?
Present.
Mr. Strasberg?
Yes, here.
Mr. Armstrong? Mr. Yanketti? Ms. Potter? Mr. Wright?
Here.
Mr. Hunter? Mr. Baines? Ms. Horvath?
I'm here, thank you.
Okay, thank you. Is there anyone who's on the phone whose name I have not called?
Her phone, I was unable to attend this morning, but I'm on the line now.
Oh, Mr. Scarfone. Thank you, Mr. Scarfone.
And that noise is Chris Hatfield?
All right.
The conference is in lecture mode.
I just before I call on Mr. Anand to make his remarks, I wanted to direct Convocation's attention to page 1860 of Board Book, just to address a factual matter. As Ms. Christensen has said in her letter to us outlining process, you'll find at that page this statement. Just before the paragraph starting with mobility issues, there's this statement. Currently, there is no process in place by which graduates of a non-accredited Canadian common law university may enter the Law Society's licensing process. The Federation's National Committee of Accreditation's mandate is to evaluate the qualifications of those with degrees from outside Canada, international degrees, and from Quebec. It was not established to consider additional qualifications that graduates of non-accredited Canadian common law schools would have to meet. So presently, graduates from Trinity Western University, as things stand at the moment, would not have the process of the National Committee on Accreditation open to them to become qualified to practice in Ontario through that particular route. All right, I'll call on Mr. Anand.
It's a point of process that may not be completely accurate. Should I just ask to speak to it later?
No, let's speak to it now.
Sure. Very simply, if somebody applied and was accepted in Quebec, they could then use the mobility, in BC, they could then use the mobility provisions to come to Ontario.
Okay, that's not the issue I was addressing.
I take your point.
But that's not correct. Mr. Anand?
Thank you, Treasurer. And like many others, I want to express my own...
Mr. Anand, could you just hold on for a moment? Mr. Campion, I would direct you to the mobility paper that was authored by Ms. Berdakos. It's in the materials that explains why the statement you just made is not accurate.
I have an answer to it, but I won't bother now.
Mr. Anand?
Thank you, Treasurer. I was just saying that, like others, I'd like to express my thanks to President Kuhn and to Mr. Meehan and to colleagues for your very helpful oral and written submission. I agree with Trinity Western's submission that this is a difficult question and that it's a legal question and that it's not a question to be answered based on analogies to other legislation or practices, that are discriminatory and of which we should all be ashamed. I want to address what I continue to regard, as I spoke to this last time, as a central legal issue. And it relates to sections 9 and 18 of the Ontario Human Rights Code. They were cited last week, and neither has been answered in my respectful submission by Trinity Western. Paragraphs 123 to 127 of TWU's submissions barely touch upon these issues. Section 9 of the Ontario Human Rights Code would put the Law Society of Upper Canada in violation of the Human Rights Code if it participates, assists, or sanctions discrimination by Trinity Western University. Section 9 is the prohibition on indirect discrimination by a party. Section 18, and I might say that I raised this issue, and in the chart of responses, the response that's given is to quote Section 9. Section 18 of the Code says that a religious institution doesn't commit a discriminatory act by limiting enrollment to those who share its religious beliefs. Now, we are bound by Section 9 and by the Charter, and the Charter operates to the same effect as Section 9. On its face, the Community Covenant requires gay or common law heterosexual students or persons of another religion to choose between their education on the one hand and their dignity and self-respect as individuals on the other. But we read Trinity Western saying that it won't, and indeed it doesn't, exclude persons who are gay, lesbian, or common law opposite sex students, and who therefore don't and can't share the Covenant's expression of religious beliefs. In other words, you can sign the Covenant and get in. So the conclusion that is stated is that Trinity Western says it's not excluding students based on, well, the conclusion is that it's not excluding students based on religious belief if they are allowing students who clearly don't share the prescriptions of the Covenant to be admitted. Now, as a preliminary point, that disqualifies them to the defense under Section 18 of the Human Rights Code, because the Human Rights Code, as I said, allows what would otherwise be discrimination where there is an exclusion, an absolute exclusion of persons based on religious belief. But this idea of signing the Covenant and getting in regardless of whether you in fact meet the requirements of the Covenant is the American Bar Association compromise that we talked about last time, and which I don't think has been addressed at all in the submissions by Trinity Western since then. So if I'm a student who is LGBTQ or common law opposite sex, I have two choices. The first is to sign the Covenant, to refuse to sign the Covenant, and to be excluded on grounds of sexual orientation or marital status. The second is that I can sign the Covenant and be admitted despite the clear prohibition of my conduct as an individual student. In other words, sign the undertaking to abide by the Covenant which precludes sexual intimacy that violates the sacredness of marriage, and that's a quotation. It's between a man and a woman, as stated in 6 words or more in the Covenant a few times. And so if I'm a student who is signed despite my sexual orientation or marital status, 2 things have happened. One is that I've made a false declaration, which is an issue of good character. and we're actually talking about the issue of admission to the bar. And that may render me ineligible for licensing in this province. The second is, I'm a gay or common law student who has to live in the closet. To conduct my life as if I'm not gay or common law, or be subject to, and I quote, the formal accountability procedures. This is at page 209A, Community Covenant. The formal accountability procedures to address actions by community members that represent a disregard for this covenant. Now, I think it's clear that to prevent a student from manifesting his or her personal sexual identity and relationship is itself a violation of the Human Rights Code. One of my colleagues may call it a steamroller. I've concluded it's a violation of the Human Rights Code. And it's clearly a burden placed on students in that situation under the Charter, if it, to the extent that the Law Society becomes implicated. And the best illustration of this, of the connection between conduct and identity is in fact in Trinity Western submissions. At page 3045, paragraph 92 of Mr. Meehan's submission, it reads, as recognized by the Supreme Court of Canada, religious belief is integral to all aspects of the lives of religious people. The right to freedom of religion includes the right to believe, the right to declare the belief openly by word or in writing, and the right to manifest that belief by worship, practice, and teaching without coercion or constraint. The members of Trinity Western's religious community are entitled to associate together and pursue education in a religious environment without hindrance, reprisal, or constraint. And we know from Ms. Leeper's comments earlier that the Anselm case in the Supreme Court of Canada also applied the scope of the Charter to a particular course of conduct. Now, paragraph 92 is in the religious freedom context, and we have Trinity Western telling us quite correctly that religious freedom involves conduct. I simply say that there's no hierarchy of rights. The assimilation of conduct to status applies equally to other grounds involving historically disadvantaged individuals, including clearly and most prominently the LGBTQ community. So Trinity Western's submission amounts to an assertion that the prohibition of conduct is prohibited, is prevented when it comes to religion, but it's permitted when the disadvantaged group is gays, lesbians, or common law couples. My suspicion is that, and my view is that Trinity Western's analysis is legally flawed. The 2001, on this issue of conduct versus status, the 2001 Trinity Western decision didn't address discrimination experienced by effective Trinity Western students, faculty, and staff while attending or employed by Trinity Western. The Christian Horizons case in the Divisional Court of this province struck down conduct-based prohibitions in a religious organization, preventing support workers from engaging in same-sex relationships. And the Watcott case, which has been referred to earlier, in fact confirmed the dissenting view of Madam Justice Leroux Dubé in the Trinity Western decision of several years before, saying that human rights law rejects the separation of sexual orientation status from conduct or identity from practice. So under the Ontario Human Rights Code, which applies to us and the Charter, the Law Society can't be a party and can't exercise our gatekeeper role so as to facilitate discrimination. I tried to set out last day my analysis of the independent duties that we have, leaving aside whether Trinity Western in and of itself is violating any human rights laws under section 4.1, 4.2, and so on of the law. In compliance with the code on our part, and in compliance with the charter on our part, and guided by the values of those documents, including Law Society Act's concerns with rule of law, public interest, and the cause of justice. So given my analysis of the situation of LGBTQ or common law opposite sex students who are required to sign the covenant, my view is that the application of these provisions require the vote against accreditation.
Ms. Murchie.
Thank you, Treasurer. I should confess that it would be easier and much more comfortable for me to vote against accreditation, as that aligns with my personal views and with the views of many of my colleagues around the table who have argued very persuasively against accreditation. But to paraphrase the Trinity Western Covenant, I've thought critically and constructively about this complex issue for the last 2 weeks, and I've been forced to conclude that I must vote for accreditation for 2 key reasons. In fact, 1 key reason. The first is that I think we're bound to do so by the law, and the second is that we should be abiding by the Federation decision. With respect to the law, I say the Supreme Court of Canada case in the Trinity Western and Teachers case governs. It was in fact the law and the submissions about the law at this table and in all of the writings and documents that we had to review that persuaded me that we had to accredit. Mr. Mercer argues very persuasively that the Law Society Act is different from the governing legislation that was at issue in the Teachers case. And that may be so, but in my view at least, in my analysis, the Law Society Act does not promote equality rights to trump religious freedom, particularly in a situation where the Balancing Act has already been undertaken by the Supreme Court of Canada in the Teachers case. So as we all know, the Supreme Court of Canada considered equality rights in respect of the Trinity Western Covenant. And they concluded that freedom of religion was not accommodated if accreditation was denied. And they went on to conclude that the proper place to draw the line in considering accreditation was between belief and conduct. And as Trinity Western has pointed out, and the materials are clear, there is no evidence that anyone graduating from a Trinity Western law school would in fact behave in a discriminatory manner while practicing law. So Mr. Brett, I think, has analyzed that case much more carefully than I have done, and I'm prepared to rely on his analysis, and indeed on Mr. McDowell's before. But it seems to me that the Supreme Court of Canada has already balanced the rights of the LGBT community, and we can't ignore their clear determination that denying to accredit TWU would be a denial of religious accommodation. This is the same Supreme Court of Canada, and indeed the rest of our courts, that have led the way in recognition of equality rights. So from my perspective, the diverse profession we all want and are required to protect includes those with religious beliefs that may be contrary to our own, if indeed we have them. On the second issue, the federation issue, I'm not saying we're bound by it, but having, in my view, initiated a process in 2010 and agreed that the Federation should look at the requirements. In my view, we should respect that determination, particularly in the circumstances when there's no reason not to. So in closing, Treasurer, I say we're bound by the law and that there is no legal reason that we have not to accredit. Thank you.
Ms. Goh?
So last time I spoke, I began by speaking about my fear that if I did open my mouth, I would be accused of having a closed mind, and if I didn't, I would be accused of being unfair, as I did not give TWU an opportunity to comment. But as it turned out, it didn't matter one way or another, because the same accusation is being leveled against me for being unfair, mainly because I dare remind the Convocation the historical facts about racism against Chinese Canadians, most notably within the legal profession, especially in the province of British Columbia, and how far we have come since then. And I stand by my comment. And as someone who has fought against racism for close to, I think, 3 decades, I personally have received more than my fair share of hate mails and offensive remarks in response to my stand on these issues. So I do have sympathy towards TWU for having received hate mails. And in fact, I have had on occasions reported some of the most violent ones to the police, not because I'm scared, but because I want to have them on record. These are often the common themes that underline some of the hate mails that I get. That the real victims of our society are not the Chinese or the blacks or the Aboriginal people who experience racism, but the white men who are the real minority in Canada, whose rights have been violated by the special interest groups. That Canada is overrun by people of color, and white people are being pushed aside. That in speaking out against racism and hate, people of color are trying to silence the white majority by taking away their freedom of speech. And regardless of the actual content of these hate mails, they are all deliberately and intentionally designed with one purpose and one purpose only: to intimidate and threaten their opponent into submission. They have never succeeded in silencing me. I'm therefore very used to the argument of reverse discrimination. I just did not expect to hear them being made so loud and clear in this room. I want to thank TWU for their presentation. Whatever questions I once had about whether I should be voting yes or no to the application for accreditation, and I do share some of the I guess, concerns that have been raised by some of our fellow benchers. Their submission and their presentation removes all lingering doubt, and I will be voting no to the motion. Voting yes, in my respectful submission, is a huge step backward in the progress of human rights since the days of Chinese attacks and exclusion.
Mr. Goldblatt? Goldblatt will be followed by Mr. Strasberg and Mr. Wright.
Thank you. Treasurer, colleagues, and representatives from TWU, I wish that I had had the opportunity to speak earlier, because had I done so, I would have obviously echoed some of the very incisive and I think quite compelling arguments of those who have spoken previously with respect to not accrediting TWU. Had I done so, however, you would have had to listen to me much longer, which is to your disadvantage. But I nonetheless feel there are a couple of points that need to be made, and I will make them as briefly as I possibly can. At the outset of Mr. Kuhn's submissions, he provided, first of all, he warned us that he might be seen as provocative and did not mean to be insulting. And these are my words, not necessarily his. But he then read a number of comments from emails and Facebooks and so on, which could only be viewed as being insightful, horrible, demeaning, and perhaps unprofessional. The comments that none of us in this room would associate with, none of us, more importantly, in this room have uttered, in a record which I think is replete with civility and respect in terms of the debate. And I understood that as an advocate and as someone making submissions, it was perhaps appropriate to provide the extreme view. Then towards the end of his submissions, Mr. Kuhn brought us into those comments. And I don't know if I have this verbatim, but I think it's pretty close. You'll recall that he described what would happen, or what message would be sent, if in fact Convocation voted against accreditation. And he said if we did so, amongst other things, we would be validating the comments that were made, and we would be approving institutional bullying. He then said that we would be providing a definition to the public interest which would make it a tool of political conformity and punishment. Now, I apologize, Mr. Kuhn, if I have not gotten those words exactly accurate, but I think it's pretty close. I want to say that when I vote against accreditation, as I will, I'm not doing so in any way to validate the comments that have been made. In fact, I entirely disassociate myself from them, and I am sure that I speak on behalf of everyone in this room on either side of this issue when they do so. I also want to say that I have no question that Mr. Kuhn truly believes in the position that he has taken and in the freedom of religion that he has advocated. And I, like others who have spoken, entirely support him in that position and would defend him with respect to that position. But in the course of his submissions, he showed very little with respect, tolerance, if I may use that word, to the sexual orientation aspect of the matter before us. And I think, quite tellingly, when he took us through the covenant, he left out that whole section he read to us, except the section that says healthy sexuality. Somehow that was not specifically read into the record for reasons that I'm sure Mr. Kuhn could explain. I understand the charter principles, I believe. I've argued a number of charter cases successfully and maybe more unsuccessfully. I've argued as well many human rights cases. I understand the legal principles, but we are not here as a court. We are here exercising our statutory discretion to determine whether we will accredit this institution. And it is not the quality of the education, but the character of the institution that we are being called upon to consider. From the very first orientation I had as a bench, it was drilled into me that we were elected to serve in the public interest. And I cannot accept that it would be in the public interest to accredit an institution such as Trinity Western, which does not accept and embrace equality among individuals who wish to practice and live a sexual orientation which might not be quote-unquote biblical, but is nonetheless something that deserves and requires respect and protection. I cannot vote to accredit a law school which seeks to control students in their bedrooms, which threatens to punish those who want to be free to be themselves and to engage in loving and meaningful relationships, but who must sign what I consider to be an offensive and a morally diminishing agreement if they want to become and remain students at Trinity Western. So I will, with what I consider to be the public interest, and I'm speaking obviously only on my behalf, vote against accreditation. But I can assure Convocation that I am not doing so as a tool of political conformity. I am not doing so in order to punish Trinity Western. I am doing so because throughout my period as a bencher, I have come to understand and accept that this society stands for, promotes, and protects equity and diversity. And that is in the public interest. And I echo Mr. Campion's words when I say I will not vote for anything that will move us 1 millimeter backward from where we are, and with respect, I believe that a vote for accreditation would do so. Thank you.
We'll go to the phone now for Mr.
The
Strasberg.
conference is no longer in lecture mode.
Mr. Strasberg, you now have the floor.
Thank you, Treasurer. I commend President Kuhn for his thoughtful and well-reasoned presentation and Mr. Meehan's written submissions. When I was growing up in Windsor in the 1950s, the 1950s, and early 1960s, I was taught by fundamental Orthodox rabbis and by Basilian priests. The Orthodox rabbis and the Basilian priests each taught me lessons about love your neighbor, truth, justice, and public service. Trinity will graduate law students who will be responsible, competent professionals who act in the public interest, especially in British Columbia. Someday in the future, a very rare Trinity law student graduate will become a redneck. Just like the Ontario lawyers who delivered hate mail to me when I was a treasurer because I established a gay, lesbian, and transgender reception at Osgood Hall in 1998. The essence of the question before Convocation today is about competence, professional conduct, and the public interest. There is no evidence of discrimination from Trinity's graduates. Maybe the covenant is good, or bad, or ugly, but the covenant is clothed by freedom of religion. The covenant is not my cup of tea, but it is irrelevant to Convocation's decision. And I ask another question. Why is the BC public interest different from Ontario's public interest? The answer is the BC public interest is generally the same as the Ontario public interest. There is no material difference. And Trinity will graduate lawyers who will be called to the BC bar. The answer to the question is yes. Thank you, Treasurer.
Thank you, Mr. Wright, are you on the phone?
I am.
Would you like to speak now? You have the floor if you'd like to make your remarks.
Thank you. I never like to disagree with Mr. Strasberg, but I have to say that I don't think that the position of TWU is particularly well reasoned. Looked at much of it is riddled with inconsistencies. If religious freedom can be invoked to deny the rights of others, then those rights have little meaning or protection. Religious freedom can be shaped to justify almost anything, from bringing a big brother culture to bear on a person's which way is determined in the womb, not by choice or puberty, to endorsing clitorectomies, to marriage of 150-year-old man, to the subjugation of women generally. This is a crack in a door that could be kicked wide open and make a mockery of the protection of rights that have been over centuries. Nothing stops TWU from having a law school, but common sense, reason, and I say Christian human decency required TWU not to discriminate against a protected right. And that's very easy to do. They need to bear in mind that the freedom to swing your arm ends at your neighbor's nose. The freedom to dictate sexual preferences stops before you reach the person that you're trying to affect. TWU desires that we accommodate a group, them, that wishes not to accommodate others, and worse, wants others to rat out those who would fall afoul of the discriminatory covenant. They ask for respect while denying respect for that group. They've invoked extreme criticisms of their position to tarnish the moderate and reasonable criticisms of their position, and that's unfair. They claim there's no evidence that they have ever been guilty of discrimination, yet the evidence of their intent to discriminate is written into their very application for accreditation. We are not prejudging the students when they apply to be called to the bar. The Law Society will not inquire into their sexual orientation or personal beliefs. What we are asking TWU behave toward their students as law societies should, and we should behave toward them when they come before us. We will not discriminate against them, and we ask that they not discriminate against them either. Law Society is prohibited from discriminating against applicants on that basis, so we should not allow the universities to do so. If we do...
Okay, Mr. Wright, could I just ask you for an indulgence for a second? Would everyone else who is on the phone right now please mute your line, because we're getting a lot of interference and we're having some difficulty hearing Mr. Wright. So *6, if you could press *6 if you don't. Mr. Wright is the only one that has the floor, so the rest of you on the phone, if you could press *6 until we call on you. Thank you. Go ahead, Mr. Wright.
Thank you. The Law Society should not allow TWU to discriminate when the Law Society itself is not allowed to and would not and should not. If we were to allow TWU to do what we cannot do and should not do, then the Law Society is guilty of discrimination by proxy, and that is an untenable position. Mr. Brett mentioned that we would not discriminate against a Jewish law school if one had been founded to get around past discrimination against them. With respect, I think that's looking at the issue through the wrong end of the telescope. What we're trying to avoid is the creation of any discriminatory barriers in respect of protected rights. If I had a vote, which I don't, I would naturally vote against accreditation, and I'm encouraged by the comments that so many benchers have made in support of denying accreditation, and I fully endorse the views of benchers who have said this in no way restricts the religious freedom of people who do not wish to engage in such sexual orientations. They're free to live their lives, but they're not free to discriminate against a group that has struggled long and hard to place themselves at the center of society and having done so with pride. Whichever bencher said we don't want to go 1 millimeter backwards, I fully endorse that. Thank you very much.
Mr. Lerner, are you on the phone?
I am, sir.
You have the floor. Go ahead.
Thank you. I certainly do not question the validity of Trinity Western's belief, and I acknowledge the right to those beliefs. I'm troubled when a right protected by human rights legislation is used to justify an apparent act of discrimination that results in the violation of another protected group's rights. While I recognize the right of TWU to freedom of religion, I do not believe, nor do I accept, that it permits or ought to infringe upon the protected right of another. No right is absolute. There is no hierarchy of rights. Each right is equal and equally deserving of protection. I cannot believe anyone ever contemplated that the assertion of a protected right could result in the violation of another protected right and an outright act of discrimination. Having read the material, having heard 2 days of debate, having attempted to inform myself to the best of my ability, rightly or wrongly, I consider this decision to be a matter of law as well as a matter of conscience. I am therefore compelled to vote against accreditation. However, if I am wrong, I will willingly accept any decision to the contrary. Thank you.
Ms. Minor?
The conference is in lecture mode.
Thank you, Treasurer. And like others, I thank the representatives of TWU for their responsive material and oral presentation today. And like others, I believe all of us here would dissociate ourselves from many of the remarks which were characterized as hate messages. That is not what this convocation is about, and I believe that our remarks are all offered with respect, with the greatest respect to the ability to hold religious beliefs. On that note, I nonetheless am of the view that we should vote against accreditation. And I will simply add some points made, 2 points made by others so that I'm not repeating submissions. Mr. Annan noted that we are also bound by the Human Rights Code. And as I noted last day, if there was any doubt about whether our public interest responsibilities extended in accreditation extended beyond looking at individual competence, the Human Rights Code Section 6, I believe, confirms that it does. Section 6 guarantees membership in self-governing organizations and professions on a non-discriminatory basis. We cannot run a licensing process which would discriminate or present barriers based on protected grounds. I asked last day, how is it that we can maintain that responsibility if we in fact accredit a law school which would change that composition of the people who are able to be licensed? Right now, the only people who can enter our licensing process are those who graduate from accredited law schools. That's the pipeline, or that's the pool. And that pool at the moment exists without restriction to religion, gender, marital status, sexual orientation. If we accredit this, we immediately change the composition of those who may enter our licensing process because persons will be excluded on those grounds and preferred on one particular religious ground because they will have different places. When the courts tell us that, and in fact TWU reminded us that we need to balance here, and they said they didn't hear much balancing. Well, when we're balancing, what the court says is you first must look at the context in which you're balancing. And the context here is the availability of professional spaces. That is to say, spaces in professional schools. We all know that there are insufficient places to meet the demand by qualified people, both in Ontario and in Canada. So the context is a shortage, a scarcity of available professional places. This proposal would not only reinforce the lack of availability to some groups, it would then give preference to others. And I would say that, along with the other sections that Mr. Anantas referred to, that we would not be abiding by our responsibilities to have a non-discriminatory licensing and admission to membership program. The courts have also told us that when we are balancing rights, that there is no hierarchy. That's been said by a number of people. They have also said that when you are looking at the particular right claimed to protect a particular group, you look at the nature of the right. It is not absolute. So a right to associate for religious purposes is a spectrum of rights. Clearly at the highest end of protection would be the right to congregate to worship. That would be protected, I would guess, at a very high level. But you have to look at what the nature of the right is. If it was a religious requirement to observe one's religion in a particular way, if it related to a particular practice that had to be conducted in order to comply with one's religious beliefs, that would receive a higher end. Where are we here? And I invited the TWU applicants to confirm or correct me when I said at the last day, I understand this is not a requirement. The code of conduct may be a requirement for its own adherence. But when we're talking about the code here, the covenant, it's with respect to admission to a school, to a law school where there are limited places. There is has been no assertion that these people, this religious group, must study, and adults must study only in the company of their own religion or persons who agree with their precepts. That's what this is about. Can there be an exclusion of those who do not practice the religion or agree? Is that a requirement? It could well be that there is a religion that requires some kind of separate study for its adherents. There's no assertion that this is. And with respect to religious accommodation, and Mr. Brett mentioned the problems of other groups, for instance, Jewish lawyers or Jewish candidates who were not able to be admitted to public law schools. Would we disagree that there could be a private law school for them or a law school with restricted admission? Obviously that's not before us, but I would submit it would be an entirely different legal analysis. If groups are shown to be disadvantaged and subject to historic discrimination, it is open under both the Human Rights Code as a special program or under Section 52 of the Charter to have remedial programs for them, and they can be exclusive. That is not the case here. There is absolutely no assertion that any member of the TWU religious view has been denied admission to another law school. There is no assertion whatsoever that this is some kind of special program or that there needs to be a special program. At the same time, accommodation normally relates to a religious requirement. For instance, Sikhs must wear turbans. Does that requirement have to be accommodated when we are looking at other safety issues? For instance, the need to wear helmets in particular cases. And that's an issue of accommodation. To what extent can it be accommodated? There is no issue here that one needs a law school for any kind of accommodation of religious belief. So I say that kind of language is misleading and not helpful. What is helpful, I suggest, is remembering that we are looking at the public interest of our whole licensing process, and we are looking at it from the prospect of Ontario. And while others, and I respect the views, assume that the public interest is the same all over, that's not what federalism is all about. Legislatures in different provinces pass quite different legislation. They would all say they're passing it in the public interest. That's what federalism is all about. And if, with respect, the province of British Columbia or another law society views it in the public interest to have that kind of accreditation, which would have that kind of effect on its pool of applicants, then so be it. There's no reason that we have to, and it does not logically follow, and in fact it's our responsibility to look at it carefully before we do it and not just follow the train. So in my submission, there is no compelling reason to afford the claim for religious rights or religious freedom a higher acknowledgement than the rights of those who would enter into the law school process, eventually to enter into our licensing process. And in my mind, that is a balancing. That's how I would do it. It is respectful of the right to have a law school. In fact, if they are, it's simply a matter of what you can do with accreditation. Some provinces have accredited, so be it. And if we down the line want to look at the MCA process or the interjurisdictional mobility process in order to afford some accommodation to the individuals, so be it, we can do it. That's down the line. We've got some years to do it. That shouldn't be what determines our position now on whether or not this school should be able to exclude those who do not agree with their religious views. And those are my submissions.
Mr. Braithwaite. Followed by Mr. Shavis, followed by Ms. Potter.
Treasurer, distinguished representatives of Trinity Western University, just let me say from the outset that I truly appreciate the words of Mr. Kuhn that you delivered this morning. They were certainly spoken with meaning and were clearly heartfelt. I've also taken into account the words I've heard from my fellow benchers, both at our last meeting of April the 10th and this morning. The choice of what to do is a difficult one, as everyone has indicated. This has been made clear by those who have spoken before me. The choice is difficult, I believe, in part because we are advocates. It is our job to argue positions on behalf of our clients. We may not necessarily agree or ascribe to the position of our client, but we would argue that position on behalf of our client in order for our clients to be heard. The difficulty I find that we face today is that we are really not being asked to advocate a position. We're being asked to render a decision on our actual positional beliefs. And this can be uncomfortable. It may even put us in unfamiliar territory. We have heard good analyses of our case law and precedents. We have heard a good analysis distinguishing those particular cases. And I've taken from each one of those, and I certainly appreciate the effort and the time-consuming work that went into each of the previous speakers. And as such, I will not enter in such an exercise myself. My comments to follow are not to endorse any pejorative statements or engage in any attacks, as we heard this morning from comments that were delivered to Mr. Kuhn. We heard from everyone that these are things that we certainly don't accept and abhor for a number of reasons. I accept religion, freedom of religion, but I do so within limits. I accept the laws of this state, but again, I reserve the right to question those laws at all times. The Charter provides me with that opportunity and the right to do so. So herein lies the issue before me as I see it. I do not see the debate before us as a hierarchical determination of laws or beliefs. I do not see this debate as one between freedom of religion and or sexual orientation. I view the issue before me as freedom from discrimination. The issue for me is about equality. So taking such a viewpoint, the issue and determination, which I will come to, and which I'll be asked to vote on, becomes much clearer. Although it has been argued that the issue before us is not about race, it's not about color, creed, or any other protected factors, or analogous to such, I would disagree. The issue is about discrimination. The covenant in the 6 words constitute constructive discrimination. I do not wish to compare levels of discrimination. History tells me engaging in comparative discrimination is fruitless and makes bad public policy. We as regulators must operate in the public interest. Now, this may be heresy, but I have difficulty religiously, no pun intended, following the letter of the law, where it leads to an unjust result. Discrimination, in my view, leads to such and requires that it be reviewed. Now, the history, and has been alluded to by others before me, of this country, of other countries, has been filled with examples of discrimination. Historically, we've seen examples of discrimination. Within this very country alone, in the early part, in the founding of this country, in the early part of this country, there has been discrimination. Discrimination within the laws of this particular country. But we also know that discrimination in canon law also. That is a difficulty I have. The difficulty I have is not wholly accepting canon law and or state law, where it raises issues of discrimination. In the early part of the history of this country, the history books will tell us, anecdotally as well as case law, that it has been bereft of injustice in terms of how it treats people of color, blacks, aboriginals, Chinese. There has been a sad history. And some of these cases have actually made it to the Supreme Court of Canada. And it's interesting if we look at the history of those particular cases, which have permeated our society, and permeated our society in referring to in every aspect of society, finding discrimination. And that discrimination would also include issues of employment, education, housing, recreation. There was no limit to it. We have laws which supported that type of operation. There's one particular case which really set out and identified, if not supported, discrimination on the basis of race prior to the Human Rights Code, prior to, obviously, our charter. I mean, a famous case called Christie versus York. The Supreme Court of Canada talked about that particular case, and that was a case that dealt with a black person trying to have a beer at the Montreal Forum. I bring up the Montreal Forum because I sweat. But it didn't work out in terms of that person being able to have his beer. And he was told, quite frankly, that we do not serve people of your color here. That's a case that worked its way through the lower courts all the way up to the Supreme Court of Canada. The interesting thing about that is that it's a case that really established that race is not a factor. But the interesting thing about this, which was really something that was permeated through all of the cases, generally all the cases dealing with discrimination in this country, is that, particularly when it was dealing with race, because they've always found a way to get around the issue of race. So although race was at the forefront of this particular case, and clearly was because that's what the owner said, you cannot have a beer here because of your race. But by the time we got to the Supreme Court of Canada, they did a balancing of issues, a balancing of factors, and they found it on because there was nothing specific in the legislation at the time dealing with race, and they said there was no positive duty to deal with the right to serve. They said that the real issue before us, they changed the issue, was freedom of commerce, so that the individual had the right to discriminate on the basis of freedom of commerce. Those are the kinds of things that have been permeating our society. There's subtle things, and that's the concern I have when we talk about the law. I don't accept the law just because it is the law. I don't accept religion just because it is religion, where it believes that discrimination is acceptable. That's the difficulty I have. And in this case, the discrimination comes out in those 6 words. And what we're dealing with here is sexual orientation. That is discrimination, and that violates our human rights code. That's the issue that I have, and it's because of that that I cannot accept the accreditation of Trinity Western University. Because in signing that particular covenant, I find signing that covenant is rather odious. Because when you sign that particular covenant, what's happening here is that all that was doing is perpetuating this type of discrimination. And when I hear the argument that, well, we might as well just lie down and accept it because the Federation has, or they can get through the back door of the NCA, or not, that doesn't give me an answer at all. That just tells me that we're abdicating our obligation to ensure equality. If we're on that particular road, and if that is in fact can happen, you can get through the back door, then I say we have to take at least the first step. We may not be able to stop discrimination, but we at the very least must take whatever steps are necessary in the public interest. If the denial of accreditation is the first step, then we must do it. Let us take that first step. I believe the evolution of time, that will be on our side. I simply can find no justification to support discrimination because I believe we have no other choice. If I am wrong on my understanding of the law, I am honored to be so wrong. I believe the law then, if that is the case I'm wrong, it's inherently wrong and is an affront to human dignity. In short, I cannot accept the accreditation of an entity which engages in a discriminatory practice, religion or state law. It is discriminatory and runs against any personal beliefs as well as public policy and our role to act in the public interest. It is demeaning, humiliating, and an affront to public, to personal and human dignity. Thank you.
If members of Convocation who have not spoken yet are wondering where they are on the list, I want to tell you that there's 12 on the list. So I just want everyone to keep that in mind as they're making their comments. At the rate that we're going, it's not going to be very soon before we get out of here. So
is that a making supper?
Chair, I just, if I may just say that for some, it's going to be very difficult to stay much past 4 or 4:15. So, and we're very desperate.
Well, I'm not sure, Ms. Roth.
No, I understand that. I just
about that, except to encourage members to be concise
exactly
in their submissions.
That's all I'm
Thank you,
suggesting.
Mr. Chavis.
Yes, Treasurer, taking your lead in light of the comments of Mr. Goldblatt, Ms. Minor, and especially the extremely eloquent and heartfelt comments of Mr. Braithwaite, I don't have anything to add.
Thank you, Mr. Chavis. Ms. Potter, you're on next.
The conference is no longer in lecture mode.
Ms. Potter? She's not on the line, so I'll come back to her later. If she's on the line, she'll get
The conference is in lecture mode.
Ms. Symes?
Treasurer, Ventures, Trinity Western University. I listened carefully, President Kuhn, this morning as you described the pain that evangelical Christians are facing in this debate in terms of vilification and what might be described as hate speech. It is unacceptable that anyone in Canada has to endure this. And the perspective of evangelical Christians has been well represented in this debate. But what's missing around this room are the voices of out gays and lesbians who are not represented equitably in our profession. It's not just as Mr. Campion described in ancient history, well, not quite ancient, Mr. Campion, that gays and lesbians were excluded or marginalized from our profession. But the status within our profession today remains iffy if a person is out and asserts their sexuality. What hasn't been acknowledged today, and I want to do it, is that how difficult this discussion must be to gays and lesbians who will be excluded from entrance to Trinity Western University because they will not be able to sign that covenant. And how exclusionary that is to young men and women who seek a legal career. Now, we are mandated by the Supreme Court of Canada in its Doré decision to apply charter values and in its Traumonchain decision to interpret and apply the Ontario Human Rights Code. And so I want to explain why I will be voting no. The freedom of religion in Canada includes the right to believe virtually anything. It is not an objective test. What would a reasonable woman believe? The only test is whether the belief is sincerely held. And there's no question, President, that your belief and your beliefs on behalf of Trinity Western are sincerely held. And as you told us this morning, a person's religion is how men and women live out their lives. But, sir, it's not a right to compel another person to comply with your beliefs and conduct. For example, everyone in this room, I presume, would defend to the end the freedom of your religion to not perform same-sex marriages. That's guaranteed. The freedom of your religion not to ordain women. That's guaranteed. But whether or not to open a law school that specifically excludes gays and lesbians and unmarried persons from sex is in fact, I say, not freedom of religion as engaged in your seeking of accreditation by the Law Society for your law school. And I simply adopt, I guess I could say concur, with Ms. Leeper's reasoning. So we come to the second reason, and that is the balancing of rights. You've heard over and over again that there's no hierarchy of rights in our charter or in human rights. And so as we face this decision today, my concern is the direction of the Supreme Court of Canada in the recent case of NS. And what the Supreme Court of Canada in that case said is that in making this decision, we must strike a just and proportional balance between freedom of religion on one side and freedom from discrimination on the basis of sexual orientation and marital status, as found in Trinity Western's mandatory covenant. I suggest that Ms. Minor's addition to this text, which is that it must be done in context, that is, when are you balancing? And the answer to that, as we divide the sides, is admission to law school. Do we do the balancing at the beginning of the process of law, at the admission to law school, or as Mr. Brett and others said, at the end of the process when Trinity Western graduates apply for admission? My submission is we do it at the admission point. We balance these two rights at the point in which a potential law student has to sign this covenant or not be admitted. What has been said over and over again is that in that decision, the admission decision to Trinity Western Law School, freedom of religion does not trump the other rights in the Charter. The rights must be balanced. And I asked you, Trinity Western, to respond. How do you propose balancing these rights at the moment that someone applies to law school? And I didn't get an answer. Those of you who practice in the area of human rights and in employment and labor law know that there are many ways that Trinity Western University could, if it wanted to, accommodate the rights of gays and lesbians and unmarried persons to their sexual identity. But at least publicly, Trinity Western University has not even entertained the possibility of accommodating differences. For example, the covenant does not apply to Jewish people. The covenant does not apply to gays. The covenant does not apply to unmarried who go to law school, who are wishing to go to law school. It is the wish or the dream of Trinity Western University, but that these people with different religious beliefs, moral beliefs, etc., are not compelled to sign the covenant. That's what accommodation is. Attempting to find a way to balance rights. Instead, what has happened is that Trinity Western University has drawn a line in the sand, an absolute. It's their right, it's their university. But without the trump card that religion supersedes all other rights, they cannot ask us to accommodate, they cannot ask us to accredit their program, because fundamentally it negates the rights to be free from discrimination on the other protected grounds. We have a long way to go in our profession to provide an environment that is equitable for gays and lesbians. We're by no means there. By accrediting Trinity Western, we are saying at the beginning of the process that gays and lesbians are less worthy of protection. They're not sufficiently important to protect. Not only is this a step backwards, but this is dead wrong. Thank you.
I'm going to go back to the phone now for Ms. Potter.
The conference is no longer in lecture mode.
Thank you, Treasurer. Can you hear me this time?
Yes. Thank you, Ms. Potter.
Thank you. I was star fixed from before, and I didn't realize that it was still on. My apologies.
No problem. You have the floor now, Ms. Potter.
Let me just begin by saying, hello?
Yeah, we are okay, Ms. Potter. Yes, we can hear you, Ms. Potter. Go ahead.
Thank you, Treasurer. I want to begin by, first of all, saying how much I feel for my fellow benchers. They've been so thorough, so eloquent, and so thoughtful in their expressions regarding this issue. And I think it's not only important for them to hear this, but particularly for the bar at large. I've read the materials. I was present for the April 10th debate, and today, although I'm not there in person, I have listened carefully to President Kuhn's presentation. The President read out a list of offensive statements that he and TWU have received on this issue. He alleged that these statements, and I quote, were adopted by TWU opponents. Well, the record must be amended. Such statements were adopted by some TWU opponents, not by all. Any inference that all opponents of accreditation for TWU is in itself offensive. The statements read out by the President are indeed truly offensive, not only to TWU, but to all who value civil discourse and the protections embodied in the Charter, and would include both those who support and those who oppose accreditation. We must, however, guard against being swayed to vote to accredit TWU because we do not want to be seen as supporting such vitriolic and offensive statements made by some. To do so out of some appeal to political correctness would ignore the blatant discrimination contained in the community covenant deemed by President Kuhn to be, and I quote, value judgments. These value judgments offend other charter rights. President Kuhn stated that opponents of accreditation, quote, are denigrating TWU's religious community. That is simply not so. TWU's right to have their faith-based school is not the issue. The issue is the community covenant, a discriminatory requirement, the details of which were articulated by previous speakers, for admission into an environment that trains lawyers who must take an oath to comply with the rule of law, to adhere to our legislative requirement to include access to justice within our mandate to protect the public interest, and who are required to comply with the Human Rights Code. The TWU Community Covenant is a document requiring one's agreement to accept conditions that are in total contradiction to the requirements for graduating lawyers in Ontario being called to the bar. As a member and supporter of the Equity and Aboriginal Affairs Committee, this requirement should be viewed as not only discriminatory against a number of groups or communities, but as regressive and unacceptable by today's standards. In my view, the issue before Convocation is not one of religion. TWU as a body can believe what it wants to believe. The issue is the requirement that individuals not only agree to comply with discriminatory behaviors, but also are required to report those who are believed to have violated the covenant. Interestingly enough, the covenant that was referred to earlier under the commitment and accountability states that TWU welcomes all students who qualify for admission recognizing that not all affirm the theological views that are vital to the university's Christian identity. But students sign this covenant with commitment to abide by the expectations contained within the covenant. So they don't actually have to agree with everything in the religious forum, but they have to agree with the covenant, which is quite interesting. So we've not heard anything that addresses what would happen to such individuals for having violated the covenant. Would they be expelled or simply shamed and shunned? Either way, the repercussions would not be good. TWU, in my opinion, cannot hide behind allegations of religious discrimination against them when the real and only discrimination is being perpetrated by TWU by the requirements of their community covenant. Finally, the approval by other bodies referred to by President Kuhn is not reason enough for us to do the same. Several wrongs do not make a right. The argument that ultimately TWU law graduates would have to be accepted by our law society and licensed, if not by the conventional route, then by some other option, is simply one side of an argument, to be determined at the appropriate time if necessary. A hypothesis or belief is just that, and no more, and should not provide the basis for accrediting TWU. I urge my fellow benchers to be mindful of our mandate to let right prevail. It is not right to put our stamp of approval on discrimination. Do the right thing and vote against accreditation. And Treasurer, I would ask for a roll call vote on this motion when it comes before us. Thank you.
I've already indicated that there will be a roll call vote, so that's not an issue. Mr. Evans?
The conference is in lecture mode.
Treasurer, colleagues, and our visitors from the TWU. In my view, it is in the public interest to, both on behalf of our profession and on behalf of the future students of the TWU Law School, that we accredit the law school. When our daughter left home for TWU quite a number of years ago, my wife and I were not excited about the fact that she was going so far away. However, we soon took comfort in the fact that she was in a safe and secure environment and that she was happy there. Our daughter has been very successful in her life, and my wife and I give some of the credit for her success to her 4 years at Trinity Western, where she received an excellent education and a great life experience. TWU is well regarded, as we have heard, for the high quality of its academic program. Because of its emphasis on such qualities as virtue and morality, TWU is a great home away from home, a place where students feel comfortable and safe. We have been critical of the community covenant, but in fairness, I think we can acknowledge that there is much in it that is positive, that it supports the university's efforts to ensure high standards of morality among the student body, even if we don't agree with all the provisions in what is quite a lengthy document. We all come to terms with changes in society and with changes in behavior or in customs that used to be looked down upon, but are now embraced as enabling us all to live in ways which are more fulfilling and more real for each of us. We each come to terms with these changes in our own ways and in our own time. We see this in our churches. What is acceptable in some churches is not accepted in other churches. Indeed, what is acceptable to some members of any church congregation is not acceptable to other members of the same congregation. If some of us are slower to move at times than others, can we not still be respectful of other points of view? If I disagree with you, it doesn't mean that I am right and you are wrong, or that I am wrong and you are right. It is our challenge as decision makers to make the best decision we can, knowing that there is no absolute right or wrong. I believe that our beloved bencher and former Attorney General Marion Boyd came closest to the mark 2 weeks ago when she said that we are all children of God. Should we not love all God's children and recognize the spark of God which exists in each of us? Let us look at the realities of the situation at TWU. It has a diversity of students. It does not ban gay and lesbian students, nor does it expel them. They take their place in their participation in campus life and activities. Jennifer Watton, an associate director at the university, advised me that anyone is welcome to attend TWU regardless of their sexual orientation or religious beliefs, and that many gay students have attended and graduated from TWU, as have students from many different faiths and ethnicities. President Kuhn, in his recent newsletter, stated that the Community Covenant, quote, asks students to respect our belief that marriage is defined for our religious community as being between a man and a woman, end quote. I think this is a fair request to respect their belief. I'm sure that most of us respect this definition of marriage, and that many of us are united with our spouse in this traditional type of marriage. For myself, I respect this traditional view of marriage, and I also respect same-sex marriage as permitted by recent legislation. I rejoice the United Church performs same-sex Christian marriages, although it took members of the church about 15 or 20 years and a great deal of soul-searching to reach this decision. Perhaps the evangelical church and other Christian churches will make this decision someday, but that is not the issue for us today. I personally would like to see the covenant worded in such a way that gays and lesbians feel that they are included and that their form of marriage is accorded respect. However, I take great comfort in the message of President Kuhn, who stated in his recent message, and again I quote, "The essence of Christian values is found in Jesus Christ, who taught us to demonstrate love and respect for all people at all times, regardless of their faith, the color of their skin, or their sexual orientation," end quote. It would indeed be ironic if a gay graduate of the TWU Law School were denied the opportunity of working in Ontario because of a decision we might make today. Treasurer, I will vote in favor of the accreditation of the TWU Law School.
Mr. Silverstein, followed by Mr. Eustace, followed by Mr. Festoriza.
Thank you very much. Heeding your words, Treasurer, I will be brief. At the outset, I would like to say that I will be supporting the accreditation process or accreditation approval today, as TWU, in my opinion, has satisfied all the necessary criteria in order to be accredited. We've heard a lot of talk about the rule of law. That's one of the reasons I want to talk about the rule of law at the end of my comments. Well, I've heard a lot of talk around the room today using the D word, discrimination. And I'm concerned that if we fail to approve this application, we're discriminating against the beliefs of students who subscribe to the Charter. People who believe in the traditional definition of marriage and who do not want to participate in a same-sex relationship. Is it wrong for them to subscribe to that belief? Should we deny them a legal education because they hold traditional beliefs? I don't believe, I still believe there's a vast number of people, maybe not a majority, but certainly a vast number of people who still maintain those traditional views about marriage. I don't know if any polls have been taken, but again, I don't think it's universally held. Today's discussion about discrimination indicates that they're prepared to discriminate against religious beliefs in a manner that is akin to what is being complained about with PW in the first place. The discussion about discrimination indicates that some benchers are basically prepared to impose a secular charter of values that heretofore has not existed in the creation of a law school. What the discussion today indicates about discrimination is that some benches are prepared to discriminate in the name of discrimination. Now, no matter how you look at it, it's discrimination. We've heard that there's not to be a hierarchical approach to rights, and yet I believe that's what would be happening if we were to turn down this application. I talked about rule of law at the beginning. This is my final point. I don't think anybody today has commented on the Civil Marriage Act, federal legislation. Section 3.1 says, no person or organization shall be deprived of any benefit by reason of the expression of their beliefs in respect of marriage as the union of a man and woman to the exclusion of all others, the traditional definition of marriage. We're bound by that legislation, perhaps even more than some of the legislation that's cited today, because it is federal legislation. In other words, to me, the covenant complies with federal legislation, and we would be thumbing our nose, unlike other law societies, if we were to turn down the application, because the covenant, in my opinion, complies with this legislation, and we should not ignore it.
Mr. Eustace. Mr. Eustace, followed by Mr. Festeriga.
Thank you, Treasurer, honored guests. I think a lot of the commentary that's gone on today would be very applicable if we were approving the law school or not. The law school's already been approved. So I think we have to sort of gear our comments to what happens next. Are we going forward? Are we going backwards? The last two treasurers of this law society participated in the formation of the reports which are before us. Those reports are positive. So where are we going? The government of the British Columbia has approved this law school. The British Columbia Law Society has approved this law school. I understand Alberta and Saskatchewan has as well. Somewhere along the way, we're going to have a graduate. Whether the graduate is set up by Bob here, and Eugene is arguing, one of these graduates is going to come to Ontario and say, I want to practice in Ontario. If the Law Society here, they're going to say, you can't practice here. Eugene will bring up an application with the Law Society as a respondent. We're going to go to court. We're going to lose. This Law Society will lose. And I think there'll be consequences of embarrassment coming from that. So what I'm saying is, on a common sense basis, I think we have to approve this. Okay.
Mr. Festeriga.
Good afternoon, Treasurer. Thank you, fellow benchers, and I'm very proud to say that for the first time. I also wish to, again, as everyone else has, welcome our very distinguished guests. Mr. Kuhn, I don't agree with much of what you said, but I thought you conducted yourself very professionally and showed a great deal of courage in coming and speaking to us here today. One thing I got to say for Trinity Western University is they have done something that I never thought would be done and hasn't occurred in 34 years, which is my wife and I agree about some social and political issue. I don't think that Bobby and I could be any more different. When you get a chance, which I hope you will soon to meet her, you won't believe she's actually married to me. Not only is she beautiful, she's incredibly intelligent. Joe will tell you she's beautiful, but I don't have a problem with that right now. But I was born and raised in a very urban environment, very urbane. I was talking to retired Justice Ferrier about my dad at lunch today. My dad grew up and played professional football for a long time at CFL. And he was in the CFL when African American players were coming over the border because they couldn't play in the NFL. And my dad spent an enormous amount of time with men of what we now say of color. And they were in our home as I was growing up all the time, because even after my dad retired, we had professional football players all the time coming into our home. And when we went to Alberta, we met with Norman Kwong, who became Lieutenant Governor of Alberta. And my dad said, whatever you do, never play cards with Norman Kwong. So they don't call him a China Clipper for nothing. But in any event, we spent a lot of time with a lot of people. Harry Jerome, who I understand was from British Columbia, passed away on Lionsgate Bridge, was a great Canadian track star, was an extremely good friend of my dad's, and who my dad lived with. He also had this strange relationship with a very unusual man who my dad referred to as Lee, who is also known as Liberace. Now, my dad would always tell me that there were gay players, but from 47 to 54 when he played, you didn't indicate that you were gay. It was something that was kept extremely secret. He also dealt with racism towards teammates and was always very proud when the teams stuck together, particularly in Montreal. It seemed it wasn't as bad for some reason when they went out west. My wife's family is, she was born and raised on a small family farm. She's German Mennonite. She didn't speak English until she went to public school, which was a one-room schoolhouse in Essex County. She is a very true Mennonite, except for her clothes. And I assure you that her church would make TWU look like UCLA in the 1960s. But when we read the issues which are being discussed here today, when we look at the issues of the covenant, we both agreed that we would never want to sign that covenant or to participate in a school which required people to sign the covenant. And we both agreed we wouldn't want our children to sign our covenant. Our son's presently in law school, and our daughter hopes to go to law school very soon. But we both agreed that it is important that the Law Society approve accreditation of this law school. And I firmly believe that's important. I'm not going to take up a lot of time going over a lot of academic stuff, because I'm just a simple country lawyer from way down in southwestern Ontario.
Yeah,
right,
you told me that once before, and I really
I remember that. Yeah, I seem to remember winning that case. But anyways, we don't go into that. But
I'll admit that.
But my position on this is that Mr. Bratt's correct, and that Mr. Eustace, I thought, spoke well on the common sense approach to the thing. I'm very cognizant to the very strong academic arguments made by people such as my classmate, Mr. Wardle, who I have no problem disagreeing with. And I also appreciate all of the arguments that have been put forward, and I listened to them very carefully. I read all the documentation, and I read all of the stuff from April 10th. But it seems to me, ladies and gentlemen, that you have to make this decision based on what we are here to deal with, which is, will these people make good lawyers in Ontario when they get called, when they finish law school and are then come here to be called to the bar? That's the issue. And the seminal point, the important point, is when they take the oath here. If they take the oath here and they abide by it, then there's no issue. If they discriminate, they being individuals who have graduated from TWU, if they discriminate against people of same, with regard to sexual orientation or race or anything, then the Law Society is here to take steps. I'm not going to, and I don't think we should, please, deal with what people may or may not do down the road. If they get called to the bar, then we can deal with those issues as they materialize. I'm not going to hold it or deal with it on the basis of what some person who's between 19 to 22, 23 years old signs, but what they do when they are out practicing law, which is what we really should be concerned about. We're not agreeing with or approving TWU's policy by giving them accreditation. We're dealing with the issue of, are they a law school which will provide an appropriate legal education to people who will come to Ontario, write the bar, and take the oath. And I see nothing in the material that can provide that suggests they're not. So I don't think it's appropriate to deal with this on the basis that we're not going to provide accreditation, and I agree with Mr. Eustace. I don't think it's a position that's going to be upheld in the long run. I don't agree with Mr. Kuhn when he says, and I just want it very clear, and I wouldn't have taken that tack if I was him, that anybody who votes against accreditation is in any way pandering to any political or social interest. But those are my submissions, and I thank you very much. And I look forward to working with each and every one of you as things proceed.
Mr. Krishna, followed by Mr. Sullivan, followed by Mr. Porter.
Thank you, Treasurer. I have entered through the back door of many rooms in my time. I was 17 years of age in England, ready to go to university, and I applied for a job in a hotel as a waiter. Big job as a waiter. They said, no, you cannot serve in the front room. We'll give you a job as a porter in the back room, which is where I worked. And why could I not serve in the front room? Because no colored boy was going to serve white people. So I have lived my fair share in various shapes and forms. I'm sorry, President Kuhn, that we have put you through this stress and exacerbated your medical condition. And I'm not going to go into the erudite and intellectual and learned arguments which I've heard in this room for 2 days. I have them all filed appropriately under for and against, and when the time comes, occasionally in the future, if I'm ever called to argue the point, I will press the right button and bring it out. But I want to talk about some more prosaic matters, and I realize we are at the end of a long 2 days debate. You'll notice, President Kuhn, that I am not being tentative. I am being firm. I've never heard so many tentative people as I heard on April the 10th. People who have never been tentative in the last 50 years suddenly were tentative about everything. I want to speak about 3 or 4 issues, and they are prosaic issues. This is not at the high level of intellectual debate that you have come to appreciate over 2 days. The accreditation process. I know a little bit about that. For 26 years, I was the executive director of the National Committee on Accreditation. And during those 26 years, we accredited foreign graduates from approximately 60 different countries. And some of those countries were very well-known countries, such as the United States and the United Kingdom and Australia and New Zealand. And some of those countries were countries which had very backward human rights or legal systems. We have accredited people from Nigeria and Uganda, which have their own views and treatment of gays. We have accredited people from Iran during the height of their crisis, and Iraq and Saudi Arabia, which won't allow women into law schools, no matter of what sexual persuasion. From China, one of the most repressive regimes, Russia, and so on. We never once asked what was the moral value of the school, or the religious value of the school, or the rule of law, the ethical value of the country that you have come from. We evaluated on the basis of the academic criteria, and then we said, you must do thus and so in order to come equivalent to a Canadian law graduate from an accredited Canadian law school. If these graduates go to Trinity Western and graduate from British Columbia, which has accredited school, and then what happens to these students when they come out? Some have suggested they go through the National Committee on Accreditation. Well, first of all, and that's just a minor procedural issue, or is it? The National Committee on Accreditation does not have any mandate at all over domestic graduates except Quebec. And its mandate would have to be changed, and that mandate change would have to be approved by the 13 law societies. They cannot do it unilaterally.
It's up to 14 now.
14, there we are. So that would be a process. Then if they got to the National Committee, let's say after all of this, what would the National Committee say to these graduates? It would say, you are required to take Canadian courses to bring yourself up to an equivalent that we require of foreign graduates. And they'll say, but I have a certificate that says I have taken all these courses, constitutional law, administrative law, criminal law, all these other courses. And they'll say, no, no, you have to first of all pay us a fee to have your credentials evaluated, go through the process for 6 months, and then we'll tell you to take the same thing. You really think that will withstand judicial scrutiny? Are our judges of that caliber that they're going to buy into that and say, oh yes, that's all entirely proper, they've got a route. We haven't blocked their route. A little extra money, 6 months more, but we haven't done anything untoward. I don't have a solution for you. I'm just telling you about some of the issues because you're bright enough to work out your own solutions. Mobility. We fought for mobility. It was a long process of negotiation, and last year, or was it, yes, just last year, Quebec came on board and everybody is on board, and for once we have true national mobility. And there are two distinct wings to mobility, what we call temporary mobility and permanent mobility. Under the scheme that is being discussed, with British Columbia having acknowledged and accredited, a TWU graduate who is a member of the bar of British Columbia can, as of right under the mobility agreement, come and argue a case and represent a client for 180 days in Ontario. We cannot exclude that person. So they have temporary mobility. For 180 days, we have to tolerate their abhorrent views. Permanent mobility is more complicated because you have to satisfy the requirement of the place where you're seeking admission, and one of those requirements is that you will have to, and if you want to look at the requirements, that they're page 1743 of board books at paragraph 5, one of those requirements is Ontario could impose any other qualifications that ordinarily apply for lawyers to be entitled to practice. One of those would be a degree from an accredited institution, and this institution would not be accredited. So you'd have a bit of an issue to resolve. Now, I say mobility is not a big issue because, frankly, we are a country that believes in provincial comity, and different provinces can have different rules. We've got 13 securities regulators. The Supreme Court turned down the national securities regulator and said, no, Nunavut should have its own securities regulator. Very important jurisdiction in the flotation of equities. You know, it's a little unfortunate, President Kuhn, and I really feel very sorry about this because the process that we adopted, now that it's water under the bridge, we can't do anything, is slightly flawed. We should have probably had this debate before we sent the approval forward, rather than having the debate after the approval has gone forward to British Columbia and the government. But anyway, that is water under the bridge. There's nothing we can do. Two short points. What do we do with an Ontario lawyer who takes up a faculty position at TWU? has to sign the covenant. What do we do with that law? Is that professional misconduct for signing that covenant and agreeing to this form of discrimination? And at the end of the day, Treasurer, I ask this question. If we do not accredit these people, who is actually going to suffer at the end of the day? Who is going to suffer? The students who do not get admitted into law schools? The students whom we deny the opportunity to pursue their hopes and ambitions and careers? The students who will be forced to foreign law schools and will have to go through additional cost and expense? Who is going to benefit? I am uncomfortable with the tension of religion and sexuality. I spent 12 years, from the age of 4 to the age of 16, under the Jesuits. I went to the Catholic Church twice a day. For 12 years, I suspect that's a little bit more than some of my Catholic friends in this room. And look what a good it's done. But more importantly, what harm did it do me? I did not have to sign a covenant. But I'm talking about the 50s. And there were certain moral expectations in a Jesuitical institution. You did not have to sign a covenant. I had a choice not to go. They said, if you do not believe in our moral expectations, you don't need to come. You're a free person. You just won't get a good education. And my father said, well, given the balancing of the two, the desire for a good education and this theoretical covenant, which is an expectation rather than something written, you made a decision. The story, however, has a happy ending. I never converted. After 12 years, I never converted. I remained a devout Hindu to this day, and proud of it. It didn't do any harm. So anyway, I'd like you to consider some of these issues in making your choices, because they are issues that are going to arise down the road. And I know some of you have said, well, we'll confront those issues when they come up down the road. It reminds me of Wolf Goodman, who, when he was an articling student, started work on a case called Imperial General Properties. He was in the Supreme Court of Canada 20 years later on that case, by which time he was a named partner. And Wolf was up there arguing with the bench, and he was saying to them, well, Your Honor, if you go that way, what would happen if you, this situation? And Your Honor, if you say what you're saying, what would happen in this situation? And the bench looked at him and said, Mr. Goodman, we'll cross that bridge when we come to it. He'd been at it for 20 years. He was at the bridge. They wanted him to go another 20 to cross the bridge. Mr. Kuhn, I'm very sorry to have put you through this, but I must say, I was impressed by your advocacy. It was absolutely superb. But my final comment, Mr. Kuhn, for what it is worth, is this. Although I have entered through the back room in many doors, the back doors of many rooms, I will assure you that in this chamber, in this building, I have been treated with nothing but the highest of respect and collegiality and friendship. No bencher ever, and I've been here 24 years, and there have been a motley of benchers in that period of time. This is the place of the highest integrity. It makes me proud to be a member of this bar, and the sentiments that were expressed to you, I can assure you, will never be shared by anybody in this room. I disagree with half of them, 50% of the time, and not the other 50%. But that 50% keeps changing. Sometimes it's made up of one group, sometimes it's made up of the other. But they are always, always just absolutely delightful, respectful, honest, good lawyers. Thank you.
Mr. Sullivan.
Thank you. Given the hour, Treasurer, I'll just say I support accreditation. The reasoning has been given before. Thank you.
Mr. Sullivan. Mr. Porter.
This has been, again, a wonderful debate. Listen to Susan Hare, Jack Braithwaite, and Krishna is a privilege. Canada is a brew of diversity, and I hope that diversity will work. I am uncomfortable with our screening thought of our graduates. The Law Society is exercising a licensing function. That function, to my knowledge, has never entailed a litmus test for opinions, which the benchers of the Law Society may regard as correct. When we attend the graduations, we observe the people walking across in front of us. We have not the faintest idea. All sorts of people with views that are in conflict with accepted legal norms get called to the bar, including misogynists, racists, anarchists. The list would go on and on. It would not be proper, in my opinion, for the Law Society to single out evangelical Christians for special exclusion on the theory that a TWU education is insufficient to correct what are perceived by critics to be character defects rooted in their religious worldview. We should not be monitors of proper thought. Thoughts change. We will become a police over thought. Thought, varied thought and belief is our clarion call of liberty.
Ms. Hare.
I decline, yeah. Thank you.
Thank you, Ms. Hare. Mr. McDowell.
Let me, first of all, thank everyone who has commended me for my courage, using that word in the yes minister sense, I suppose. Usually, courage coming before a fall. Let me speak to the intersection of faith and the public interest. Secondly, applying the law with a question mark after it. And third, a word directly to Trinity Western. You may have thought, and I've thought of this over the past few days, the story of a man who's marooned on a desert island. And his rescuers come after a year or so, and he's showing them around the island, and he says, I've built 2 churches over here. And they say, why 2? And he said, well, I worship in this one, but I won't set foot in that one. And to me, we can smile at that because it points up the power that still lies in sectarian difference. And in the exercise of our discretion, we have to put aside our differences in faith and our views of the repugnance of other faiths, and in this case, of some of the aspects of the community covenant. And so I say respectfully that, for example, Ms. Boyd's excellent theological question, to which I'll return, is for another day. Something that the opponents of accreditation have simply ignored is the accommodation that was made when same-sex marriage came to being in the Civil Marriages Act. I won't read it for you again, but it preserved a zone of protected thought and belief around traditional marriage, so that we are going to give every benefit of the law, federally and subsequently provincially, to same-sex marriages, but it carved out a zone of freedom of conscience and religion around the tenets of traditional marriage. And so this is why, for me, I can't look at this situation through the lens of Dr. King in the speech from the Birmingham jail. That I can't look at it in the same terms that Jack Braithwaite looks at it. I think that it is too easy to look at this and say it's like the Bob Jones University case. And in our consideration of the rule of law, as many have implored us we have to consider this zone of protection which surrounds the intersection of the law, of faith, and of same-sex marriage. This is why we can't grant conditional approval, as attractive as that might be, but you can't protect freedom of conscience and religion by saying we recognize that you have that right, but we're going to ask you to renounce part of that right in order to be approved. So Mr. Mercer, in his submission that TWU as gatekeeper should not impose limitations that the Law Society would not impose itself. There is a clean logic to this, but I say that this conflates the role of the regulator and the regulator, first of all. Secondly, we make no inquiries of anybody else, as a number of people have said, whether on gender issues, whether particular institutions protect equality in the way we would like. And I question, and I'll return to this, whether we're entitled to make these inquiries at Trinity Western, given what I see as the choice, just touched on by Mr. Krishna, the choice of association in a community with minority religious views. So I ask myself the question, if we don't accredit, are we applying or creating the law? And the passage, which I just can't seem to get myself around, comes from TWU 1 to state that the voluntary adoption of a code of conduct based on a person's own religious beliefs in a private institution is sufficient to engage Section 15 would be inconsistent with freedom of conscience and religion. So I hear Mr. Campion, but when we're talking about the imposition of the covenant, we have a clear question that needs to be sorted out, whether this is a voluntary decision or whether this is a coercive decision. As matters stand in my reading of Anselm, we don't inquire into the tenets of faith. As I read Whatcott, we permit the expression of religious beliefs which offend the dignity of gay and lesbian. And this is why the BC Civil Liberties Association said we have a long history of supporting the LGBT community in every one of its important battles, but we can't do it here. Now, Mr. Mercer, in a moment of what I thought was great candor, said we are working through the place of freedom and of religion in our public and constitutional law. And I think that's a fair way of putting it. I acknowledge that I'm not omniscient about what the Supreme Court of Canada will do. First there's the securities reference, then there's the Nadal case. We may get to a place where the court says that we will not protect religious beliefs to the extent that they collide with our notions of equality. We might no longer give public funds to separate schools. We might want to create a hierarchy of rights within the charter. We might advocate a secular charter, as Justice Noda Jude has done in Quebec with great vigor. We might want to withdraw charitable tax status from institutions which do not adhere to our notions of equality. But these are all big questions. These are all big questions. And I don't think, on my reading of the case law, that we are there yet. And I look at the primacy of faith, both in the preamble to the Constitution Act and in assigning within the Charter the fundamental status to the right of freedom of conscience and religion in saying that. So, distracting myself by watching Mr. Braithwaite and Mr. Anand's team, my team, the Montreal Canadiens, I've been thinking of this, and I'm thinking that Mr. Mercer, Ms. Rothstein, Ms. Miner are the Gretzkys and the Lemieux. They're seeing that here's where the play is developing. Here's what the court's going to do. Here's where I have to go because that's where the puck's going to be. I'm the big stay-at-home defenseman. I'm the Moose DuPont of the piece. Unfortunately, I can't get myself to that point. That if we have to apply the law in our consideration of the public interest, I don't think we are permitted as a matter of law not to accredit Trinity Western for all the reasons I've said. Now, let me close with this. These are observations. President Kuhn, sir, you said that you would be provocative. Let me be provocative back. And I say this as someone who supports your accreditation. But Ms. Boyd's question, I think, does deserve an answer, not here, but within your own prayer and reflection and fellowship and consideration. Ms. Boyd asks, if as a religious person I believe that God created us all, that God loves us all, then what do I make of a human institution that tells people they can't be who God created them to be? And I say that just as our jurisprudence is not immutable, the covenant is not immutable. It has changed in relation to sexuality. It has been relaxed a little bit in my reading of it. It has changed in relation to the questions of smoking and drinking. And I'm sure that you will reflect, and probably you are reflecting, whether it should evolve to treat matters of sexuality, whatever the biblical origins are thought to be, as matters of conscience. And in saying that, I've reflected that for 35 years after Benchers first sat in this room, homosexuality, or sodomy, was a capital crime. It was until 1869. It remained a crime until 1967 and Mr. Trudeau's omnibus bill. It was treated as a mental illness until that changed in the late 1970s. It became a prohibited ground of discrimination in the 1980s. It goes on and on and on, and my point is the world is changing and it isn't changing back. The importance of this, I think, is reflected in some of the submissions you've heard from my colleague Ms. Hare, from my colleague Ms. Goh. I've struggled to try and fit those into my thinking, but the importance is this, that particularly for our young people, the feeling that this is tantamount to racial discrimination becomes a self-fulfilling thing. That this is seen as, and it will be continue to be seen as, the civil rights movement of our generation and the generation after. I predict that the covenant will change, not because of anything we do, but because your own law students will make the change. The same way that Queen's law students made Queen's secularize its convocation processes in the 1980s. And I think that will be a good thing for Trinity Western. I think it will make a great university a greater university because of the inclusion that that will mean for your university, which is, like any university, a community of scholars. I believe that every university deserves to have my friend Mark Berlin teach there. And I say all of that with the greatest of respect, sir. Eventually, seen through the lens of history, as Mr. Faulkner says, I believe our children will say this is all irrelevant because Trinity Western, with the passage of time, has changed its own. Thank you, Chair.
Okay, to let everybody so I want to make sure that everyone has an opportunity to speak. I have 3 speakers left on the list. Ms. Rothstein, followed by Mr. Callahan, followed by Mr. Ferrier. And then we will...
Treasurer, who is Moose DuPont?
Hockey player.
I mean, Butch Bouchard, I would have understood.
Butch Bouchard. I've admonished Benchers from making reference to materials that are not in the... especially references to hockey cards.
Judicial notice.
In response to you, President, I want to make very clear where I come from. I agree that TWU is entitled, very entitled, to religious freedom and religious conscience and freedom of conscience, and that we Benchers, Ontarians and Canadians must accommodate TWU's adherents those rights to deeply and sincerely follow their faith. But in my view, it is nevertheless hypocritical for TWU to complain that we, who oppose accreditation, are intolerant of TWU's adherents' religious freedom, when it is TWU that will not tolerate conduct by its prospective students and students, which is absolutely integral to their human dignity. practice their religious beliefs, and to engage in loving and sexually intimate acts with whomever they choose within the privacy of their own homes. In my view, it is unfair to say that those from whom TWU seeks a very significant privilege, we the Law Society, the privilege to be accredited by us, that we must nevertheless be tarred with the label of religious intolerance because we as a Law Society insist on this, that all law schools which we accredit permit access to the halls of the legal academy without direct or indirect barriers based on prohibited grounds. That's all we insist on, nothing more. We are not intolerant of TWU's views, or of their teachings, or their sincerely held beliefs, or indeed how they govern others in the privacy of their homes or in their churches. But yes, we are intolerant of what we view as the covenant's coerced imposition of those views on the rights of non-adherents. So I may not and cannot accredit TWU.
Mr. Cowan.
When we last spoke, I had outlined my preliminary thoughts, and I have thought a great deal about it since then. If you recall, my view was this was a legal determination at its core, that we are dispensing with a privilege or a right, and that we had to have a standard of correctness. In other words, this isn't a matter of our own personal views, our own beliefs. And for that reason, I looked last day at the law as I understood it. Since then, I've come to the view that it is a matter of charter values and a determination as to how to reconcile two conflicting charter values. I'm fortified in part by the opinions from Tories and Oathsers on that point, and that we will be held to a standard of correctness when someone looks back on this. And so it leaves us having to look, in my view, to what the law as it is. As Mr. McDowell so eloquently pointed out with yet another hockey analogy, that history may judge those of us who are interpreting the law today as not being as advanced as those who are going by their own personal views. But there you are. That's where we're at. They're entitled to a determination of their rights as it exists today. To my view, we have to look to what, in particular, the Supreme Court of Canada has said. And I say that because the determination made in this room and the debate in this room is not about our home statute, per se. It is really about how we view the public interest and how we view the public interest as it relates to the conflict between religious freedoms and the freedom of equality. And so, I feel compelled to look to the case law, and I last time referred to TWU, the case. And I am cognizant that the Supreme Court of Canada spent a great deal of time considering and balancing those rights, not for the benefit of TWU, not for the benefit of Convocation, but for the benefit of all Canadians. And that if we're going to live in a rule of law society where precedent matters, where we're going to have decision makers who follow the rule of the law of the day, then we as subordinate decision makers, albeit with a modicum of discretion, are going to have to listen to the Supreme Court of Canada. That's the way our system works. It ought to work that way, because we are just one of many administrative bodies making decisions about people's rights. And people must have the confidence that they come to these administrative bodies that we apply the law as it is seen for all Canadians, not our own personal view necessarily. You know, and it sounds unfair. As I said last day, in Regina versus Bedford, the Supreme Court of Canada was unashamed about saying it's unfair. We lie on the vertical axis of precedent we must follow. They lie on the horizontal axis. And there are many people in this room who probably have a better insight to the Supreme Court of Canada than I. And indeed could probably tell you the Supreme Court of Canada, as it currently composed, may go this way or that. I don't have that luxury. So I went back because I was most intrigued, particularly by Bencher Syme's eloquent comments. And I tried to look to see, well, how much since TWU things have changed. And there certainly are some changes, but I don't see that there's a fundamental change. In NS, for example, the Supreme Court of Canada said to remove religion from the courtroom is not in the Canadian tradition, and then went on to balance those rights. That's in a courtroom. That's not in a private institution. That's not in a private institution coming to ask for accreditation. So religion, even at the base of our civil society and our civil dispute, exists and is accepted. I went to Watka, and in that case, as we've heard, it dealt with hate speech as it related to homosexuals. And yet the Supreme Court of Canada said, Mr. Watka and others are free to preach against same-sex activities, to urge its censorship from the public school curriculum, and to seek to convert others to their point of view. They said it went on to say it's not unlimited. It's limited so far as they can't use hate speech. But clearly, they were entitled to preach, to urge censorship, and to convert others to their point of view, no matter how repugnant many other people believe those views to be. And I came away from looking at the cases that yes, there are changes, but at the core of what TWU discussed, things had not changed to that great a degree. Some here have said, oh, well, they don't have the same statutory mandate. But in that case, they were talking about teachers, educating teachers. Can it be said that there should be less diversity in our teaching faculty than there are in our law school and in our legal world? I wouldn't think so. Should teachers be less tolerant of the secular values in society, such as equality? The Supreme Court of Canada didn't think so then, and I don't think so now. I'm not sure I see the difference. And I come back to the passage I read last time and said, if this private institution can create itself on its auspices of its religious beliefs, if it can educate, then it cannot be reasonably concluded, and this is the Supreme Court of Canada, that private institutions are protected, but their graduates are de facto considered unworthy of fully participating in public activities. And so I look at where we sit, as I said last time, in the spectrum. We sit at a point in time not where we can actually tell Trinity Western not to exist. We can't tell them not to exist, not to have the covenant. We're at a point in time where, thus far, the Supreme Court of Canada say they can exist and they can have their covenant. The question is, can we de facto tell their members or their students that they can't be admitted to the society? Are we going to say to them that the Law Society of Upper Canada is not for everyone? It's not for you. And if we are, as Mr. Krishna says, have we said it to others? Is it the standard we're applying to others? And I say all this with full recognition that in time, the Supreme Court of Canada may decide that that balance is not the balance that was in the TWU decision. That they may well say that the balance of society is now in favor of equality rights, and that this is too much action against equality rights to be protected by religious rights. I accept that can be an outcome, and it may be the outcome that we live with at the end of the day. But as I sit here today, when I look at trying to determine the rights of these de facto students and the rights of this institution, the law doesn't drive me there. And I'm sorry that I'm not sorry, I accept that in our role, that's what I have to do. And I should say to TWU, the views around this room are heartfelt. It's not with anger, as though some are very strong in their views. These are people who are really grappling with a social issue that they're trying to assess and where we in the Law Society fit. And I hope everybody recognizes that who's watching and hearing these debates. This is a societal issue, and it will remain a societal issue for years to come. Thank you.
Mr. Ferrier, I believe you have the last word before we take the vote.
Thank you, Treasurer. I will be very brief. I think the issues have been dealt with thoroughly. I agree with the submissions made to the effect, I think Mr. Campion was the first to say this, that the issue is at the time of admission to law school. That's what this is about. And some students will be discriminated against in their application for admission because they will not be able to undertake the covenant. And that lies at the core of my position. I agree with the legal analysis that has been made by Mr. Mercer, Rothstein, and others. And I respect the opposing point of view, but I don't agree with it. And some of the speakers have made personal references, which I didn't think were going to be permitted, but they were, so I'm going to make a personal reference.
I'm not going to permit it.
With a brief anecdote.
Better to ask forgiveness.
And this concerns a Protestant Christian in a Catholic university. In 1959, when I was admitted to its law school, the University of Ottawa was a Catholic university run by the Oblates of Mary Immaculate, which is an order of Catholic priests. In our first year law, we even had a priest as one of our lecturers in legal history and philosophy. I had been born into a Protestant family and was so raised during my formative years. And I add, it was a Baptist family. And I was baptized when I was 14 years of age. Not with the holy water on my forehead, I was a fully immersed Baptist. The term has been. The tenets of the Catholic Church, of course, were well known as today. I did not then and do not now adhere to many of the tenets of the Catholic Christian Church. Had I been required to undertake a covenant adhering to those tenets, I would have not been able to attend law school in Ontario because my personal circumstances at the time were such that Ottawa U was my only option. I would not have become a lawyer, a bencher, treasurer of the Law Society of Upper Canada, or a judge of the Ontario Superior Court of Justice. Although the Catholic Church, the presence of the Catholic Church was everywhere on campus. Everywhere. No covenant was required of me. That is the difference. I respectfully will be voting against.
All right, that concludes our submissions, our deliberations. We're now going to move to the vote. As I mentioned earlier, vote will be recorded. I'm going to ask Mr. Varro to read the question. The response for each venture should be yes, no, or abstain. Mr. Varro?
Thank you, Treasurer. The question: given that the Federation Approval Committee has provided preliminary approval to the Trinity Western University Law Program in accordance with processes Convocation approved in 2010 respecting the national requirement, and in 2011 respecting the approval of law school academic requirements, should the Law Society of Upper Canada now accredit Trinity Western University pursuant to Section 7 of Bylaw 4?
So the question on the floor has been put.
Is there a motion second?
Sorry?
Is there a motion second?
It's not a motion.
It's not a motion.
Yes.
All right, so we will start the roll call.
Mr. Anand?
No.
Mr. Armstrong?
The conference is no longer in lecture mode.
Mr. Armstrong? Ms. Backhouse?
No.
Ms. Boyd?
No.
Mr. Braithwaite?
No.
Mr. Brett?
Or?
Excuse me, we can't hear the votes on the phone.
Mr. Bird?
Yes.
Mr. Callahan?
Yes.
Mr. Campion?
No.
Ms. Corsetti?
Yes?
Ms. Dixon?
No.
Ms. Doyle?
Yes.
Mr. Earnshaw?
No.
Mr. Epstein? Mr. Eustace?
Yes.
Mr. Evans?
Yes.
Mr. Faulkner?
He said he was on the phone.
Mr. Faulkner?
Mr. Ferrier?
No.
Mr. Festeriga?
Yes.
Ms. Go?
No.
Mr. Goldblatt?
No.
Ms. Have?
Yes.
Ms. Hare?
No.
Ms. Hartman?
Yes.
Ms. Horvat?
No.
That was a no, Ms. Horvat?
That was a no.
Thank you. Mr. Hunter?
Yes.
Mr. Krishna?
Yes.
Mr. Laurie?
No.
Ms. Leeper?
No.
Mr. Lerner?
No.
Ms. Lippa?
No.
Mr. McKenzie?
No.
Ms. McLean?
Yes.
Mr. McDowell?
Yes.
Ms. McGrath?
Yes.
Mr. Mercer?
No.
Ms. Minor?
No.
Ms. Murchie?
Yes.
Mr. Porter?
Yes.
Ms. Potter?
No.
Mr. Pustina?
Yes.
Mr. Rabinovich?
No.
Ms. Richardson?
No.
Ms. Richer?
No.
Ms. Rothstein?
No.
Mr. Shabus?
No.
Mr. Chef?
Yes.
Mr. Silverstein?
Yes.
Ms. Strasburg?
No.
Mr. Strasburg?
Mr. Strasburg?
Mr. Sullivan?
Yes.
Ms. Symes?
No.
Mr. Wardle?
No.
Is there anyone whose name I have not called?
Mine, Scarfone, and I have to abstain, as I did not hear the submissions of the university.
Thank you, Mr. Scarfone. Anyone else? The answer to the question is no, 28, yes, 21, with 1 abstention.
Okay. Ladies and gentlemen, we'll be taking a short break. I will be attending a press conference right now, but we do have other business, so please return after the break so that we can conclude the agenda for today.
How long do you want it? 15 minutes?
20 minutes. I'll be with the press. Okay. Well, we've got a number of items. They're mostly consent agenda items. There are, I believe, in fact, there's 1 or 2 issues that we'll have to come with today. So
financial statements.
I just beg your indulgence and your patience, and come back for those of you who can, so that we don't lose quorum and we can conclude today's business.